Hey guys, hold on one second. I just had a blonde moment. Stellar way to start things off. There you go. Hi. Oh, wow. Okay. Hello, everyone. Welcome to this special cruise edition of Criminally Confident. My name is Lacey Jane. And like I said, my channel is Criminally Confident. Thank you so much for being with me today. We are doing a little bit of a restream here. And what we are going to be talking about is important because it relates to some of the activities that have been taking place recently up in Minnesota. Uh, if you are not aware, about last week, we had a woman who she had been protesting, and long story short, she used her vehicle to come after a federal agent, for which she was shot, and she was unfortunately unalived. And if you're new here, I have to use certain language because of YouTube getting its feelings hurt, and it's ridiculous. Because you will also know, if you are not new here, I am all about freedom of speech. So, with that being said, I am hoping that you can hang in there with me through the weird works of words. And if you have any questions about this, let me know. I also want to give you a heads up. This system, this setup, we are trying something entirely new. So if you notice anything glitchy or if you hear double audio, please let me know. Oh my God, Becca, thank you. Becca coming in hot with $9.99. Thank you so much, Becca. You are so great. So happy to have had you on Friday. And yeah, like I said, if we have any weird technical issues, please let me know. I'm wearing a mic today. I hope to God it's working. I have headphones. I'm about to put them on. Let's get this thing going. Thanks guys for being here. And if you haven't done so already, please make sure to like the stream and double check and make sure that you are subscribed to the channel. It helps get this out to as many people as possible. And I think that you'll pick up what I'm trying to throw down as we go through this, and the similarities, and why people continue to put themselves in between federal agents is just like baffling to me. So let's go ahead and get started.
The defendant, Connor Grubbs, chose to fire his gun at Takaya Young, striking her in the chest and killing her and her unborn child. The defendant was a police officer with Blendon Township Police Department at the time of the incident. He was on duty, assisting someone who was locked out of their vehicle in the parking lot of Kroger, located at 5991 South Sunbury Road in Blendon Township, Franklin County, Ohio. Another Blendon Township police officer, Sergeant Eric Moynihan, was also present at the scene. As the officers were in the parking lot, Takaya Young exited the Kroger store and entered her vehicle
With a bag full. The video, hold on. I keep hearing myself double, so I'm not sure how else to do this. But basically, the the audio is really low at the beginning part of this stream. Just a heads up, guys. There's nothing I can do on this end. This happened in real time. They got it fixed, I want to say, after day one, but I will turn on closed captioning. So hopefully that helps. Sorry about that. We're also doing a get ready with me. I should have mentioned that as well. Of liquor.
A Kroger employee also exited the store and told Sergeant Moynihan that Takaya Young had just stolen items from inside of the store. Takaya was still in her vehicle in her parking spot. So Sergeant Moynihan proceeded to knock on the window of her car, telling her to get out of her vehicle and that the employee had just stated that she had stolen something. Takaya Young refused to exit her vehicle. Defendant then walked to the front of Takaya's vehicle and drew his firearm, pointing it at her and commanding her to get out of the fucking car. At that point, Takaya attempted to leave the parking lot. Defendant was standing in front of her vehicle near the driver's side. Takaya actually used her right turn signal and began to slowly move her vehicle forward, turning her steering wheel to the right. As she inched forward, defendant still remained standing in front of the vehicle. Defendant actually first placed his hand on the hood of the vehicle. Defendant then took several steps backwards, moving with the vehicle. Ultimately, defendant was easily able to step back and to the side of the vehicle to avoid harm, as the vehicle was going so slowly and turning to the right, away from him. However, as defendant was moving back into the side of the vehicle, his firearm still drawn, he shot his gun through the windshield of Takaya's car. The bullet struck Takaya in the chest and immediately incapacitated her, leaving her vehicle uncontrolled. The vehicle continued moving and came to rest after running into an exterior wall of the Kroger store.
The pharmacy.
Takaya Young died that day, as did the unborn baby girl she was carrying inside of her. Numerous officers responded to the scene as a result of the shooting. Efforts were made to render aid to Takaya, but due to the nature of the gunshot wound, she did not survive, and neither did. There's no question that Takaya stole liquor bottles from inside of the store that day. The evidence is going to show that. The state is not going to dispute that. But the state is here before you because absolutely no one should have been killed for taking the actions that Takaya took that day. And as a result of defendant's unreasonable and unjustified decision to stop Takaya with deadly force, he stands accused of the charges the judge previously read to you. At the conclusion of all the evidence, there will be no question that the defendant knowingly fired at Takaya Young. There will be no question that as a result, she was struck in the chest and died. There will be no question that her unborn child died as well. So this case ultimately comes down to the question of whether or not defendant's decision to use deadly force was justified. At the end of the trial, you'll receive detailed instructions from the court on the applicable law.
Sorry, guys, I was sick when I was doing this.
The answer is this. At the time defendant chose to use deadly force, did he reasonably believe that Takaya presented an imminent threat of serious physical harm or death to himself or to others? And that question is to be answered from the perspective of an objectively reasonable police officer. And after all the presentation of all the evidence, the state is going to ask you to find that the shooting was not justified because no reasonable officer could have reasonably believed that Takaya Young presented an imminent threat of serious physical harm that day. Defendant drew his firearm and placed himself in front of Takaya's vehicle due to an allegation of shoplifting. And even then, he was still able to step out of harm's way with ease, as she was clearly turning away from him and moving her car so slowly. The evidence shows that she was not running over the officer with her vehicle, and that the shot fired by defendant was utterly unnecessary to defend himself. He was easily able to step aside to avoid harm, and avoiding harm had nothing to do with his decision to discharge his firearm. He wasn't defending his life or anyone else's. He was simply stopping her. During the trial, the evidence will show that a typed statement by defendant was provided to BCI investigators. BCI is the Bureau of Criminal Investigations, the investigative agency for the state attorney general's office. The evidence will also show that much of what is described in the statement by the defendant as to the justification for why he fired his weapon and killed Takaya is different from what is depicted in the video of the incident. The evidence will also show that after the incident, BCI processed the scene and no firearm was found on Takaya's person or inside of her vehicle. You will also hear
She
from
wasn't there
Professor
knitting a
Seth Stokes,
sweater.
an expert in police
Sure.
tactics and use of force. And you will hear about how defendants' actions were contrary to generally accepted police practices and policies. You'll hear from Dr. Jeremy Bauer, an expert in biomechanics. Dr. Bauer will tell you that based on his analysis of the video evidence, the positioning and movement of defendant at the front corner of Takaya's vehicle is not consistent with the defendant being in imminent danger of death or serious bodily harm. The state is not here to put law enforcement on trial or to condemn police officers in general. The state has profound respect for law enforcement. It is one of the most essential roles in any functioning society, and the state works closely with law enforcement every single day. But no one is above the law either. And on August 24th, 2023, 2 lives were unjustifiably taken by defendant. And that's why the state will ask you to put aside all biases, preconceived notions, and follow the evidence to the only logical conclusion. The shooting of Takaya Young and her unborn child was unjustified. Takaya Young posed a threat of serious harm to no one, and no reasonable officer could have reasonably believed that she did. The state will ask you to find defendant guilty of each and every count of which he has been charged related to the deaths of Takaya Young and her unborn child.
Any opening statements on behalf of the defense?
Thank you. May I have a moment to set up?
You may.
Thank you.
He's lost a bunch of weight. I'll make sure to show you guys the photos that I took from the crime scene. And Anthony, you are correct. I don't know how I missed that. So yeah,
May I have the
I'll cover it.
evidence card, Ms. Cook? I did test this out before while we were on break, so hopefully it goes according to plan here. May I proceed?
May?
May it please the court, Mr. Collins, Mr. Grubb, Mr. Glennon, Mr. Brandt, Ms. Claypool. Good morning. Don't let the prosecutor confuse you. This case is not complex. It's really rather quite simple. The essence of this case comes down to one line. One line that won't be given to you by either one of these prosecutors, and one line that won't be given to you by we as the defense. But rather, the essence of this case comes down to something that you will hear from Judge Young himself in the jury instructions. And that is an immediate threat to the officer or others of serious physical harm or death will permit him to respond with deadly force. An immediate threat to the officer or to others of serious physical harm, a broken back, a broken hip,
Yeah.
a skull fracture, serious physical harm or death will permit him to respond with deadly force. Now, the jury instructions are what you will be required to follow while you're back there and deliberating. And this concept will be in those jury instructions. Now, neither one
Here it
of
is.
these prosecutors will be able to refute the fact that a 3,500-pound car
Human
is
missile.
capable of causing both serious physical harm, a broken back, a broken hip, a skull fracture. They won't be able to dispute that certainly a 3,500-pound car can cause serious physical harm or death. They won't be able to dispute the fact that a 3,500-pound car can be weaponized into a deadly weapon in the matter of split seconds. So why then was Miss Young an immediate threat to the officer or others when she possessed a 3,500-pound deadly weapon with her foot on the trigger, the accelerator? Why was she an immediate threat? Let's talk about it. On August 24th, 2023, you're a police officer. You're working a normal summer afternoon shift. On this day, you were called out to the local Kroger to assist an elderly woman who locked her keys in her car. Parked right next to where you've responded is a car that's backed into a handicapped parking spot. That car has no license plate. It's backed into a handicapped parking spot, and it's got no handicap placard. It's parked in the manner in which somebody may need to get a quick getaway, punch the accelerator, and get out of Dodge. You're no rookie. You know that's suspicious.
I've had to have that done to my car more than once. So I was this way.
A Kroger employee then comes running out of the Kroger. Someone has robbed the store of liquor items. That suspect is ducking into that car with no license plate, no handicap placard, and the one that's parked in a handicapped parking spot, but backed in.
It's like premeditated.
Your sergeant, he's been on the job longer than you, immediately goes over to the suspect in that car. He's standing at the driver's side window of the vehicle. The suspect is refusing to comply with his orders. The officer, your sergeant, Sergeant Moynihan, is trying to de-escalate the situation. The suspect, the one accused of the theft, she's in control here. She can stop the problem.
Too much of a loss for 10.
Out of the car.
Now, you realize your sergeant is telling someone to get out of the car. You realize your sergeant may need help, that this person may be charged additionally with resisting arrest, with obstruction of justice, with obstruction of official business. Not only do you realize that your sergeant might be in danger, but there are at least 4 other people in that Kroger parking lot that you can see as you're approaching the suspect and your sergeant. One is a child with a grocery cart, pushing the cart back to the return. Now, as a police officer, you were trained in contact and cover. That when one officer makes contact with a suspect who's already refusing commands, a suspect who very well may be willing to hurt you or kill someone else, that when that officer makes contact with that suspect, your job as a police officer is to cover that sergeant. Where is the only place you can safely cover your sergeant and make sure no other innocent civilians are in the way? It's the front of a stationary parked car. Now you'll notice there are no taillights in that car. That car was not moving. That is the only place to safely cover your sergeant and not put any of the other civilians in harm's way. You stand in the front of the car because a reasonable person would see that an officer, a uniformed officer, is not only to the left of your driver's side, but is also standing in front of the car. You stand in front of that parked stationary vehicle because a reasonable person doesn't then start the car, doesn't drop the car into gear, and doesn't proceed to drive that 3,500-pound deadly weapon into a uniformed police officer. Any other position in that parking lot could have put innocent civilians in harm's way, could have put civilians in a position for crossfire should that suspect have had a gun. But the suspect, Mr. Glennon was right, did not have a gun, but she possessed a 3,500-pound deadly weapon and put her foot on the accelerator. That child reclaiming that shopping cart all the way to the left of the screen. She will be the first one run down if this suspect peels out and tries to make a break. That child needs protecting too, so you stand in front of a stationary parked vehicle. Contact and cover.
Out of the car. Out of the car.
7 back in service, 1828.
Your sergeant is to the right. Certainly you can't stand right next to the sergeant and still safely cover him. A Kroger employee is by number 2. And number 3, you can see the top of the elderly woman's head just below that handicap parking sign. The elderly woman who you were just assisting.
Can you guys hear me now?
The other way, here's your view. Again, 4, 5, 6, 7, 8. There are people, innocent civilians, all over this parking lot. Now the suspect is still refusing to de-escalate.
Make sure to like and subscribe, guys. I saw that we only have 3 likes, so let's get that up. Thank you.
Police are required by law to investigate crimes like these. She needs to be placed under arrest for not only officer safety, but for everyone else's safety in that parking lot. And because you know that because that car has no license plate, if she flees, if she commits another crime in the process, like hitting down that child with
Exactly.
a grocery
They
cart,
wouldn't be able to find her.
because there's no license plate, you as a police officer have no way to track that car down. Your sergeant is about to break the glass on the window to get the suspect out of the car. She's continuing to resist. She's increasing the danger and becoming more volatile.
Get out of the car. Then get out. No, then get out.
At some point, she starts the car.
Ohio in the chat, guys.
You are trained to know that sometimes suspects in vehicles who are already resisting arrest, sometimes those suspects want to hurt you. You're trained that sometimes police officers get run down by vehicles. Even a slower moving vehicle can still cause a broken hip, a broken back, a skull fracture, a traumatic brain injury if that car bumps into you at a slow moving pace and you fall and crack your head on the pavement. You know this. Then she pulls the trigger of that 3,500-pound deadly weapon. A quarter of an inch push on that accelerator, and that kid returning the shopping cart may be run down. You may be run down. She's coming at you. Her tires squeal. The sound of a peeling out. The sound of a car that's about to go very fast. You try to move out of the way, but it's too late. Her bumper, her moving bumper, comes into contact with your legs. You try to brace yourself for impact, you go up on the hood, but both feet leave the ground. And in 1.665 seconds, faster than someone can snap their fingers 4 times, you have to make the decision to defend yourself. You fire just one shot. Because one shot is all it took to stop that vehicle from sucking your feet under and pancaking you onto the pavement. One shot was all it took to stop that car from running down anybody else in that parking lot.
Get out of the fucking car. Get out of the car. Get out of the fucking car.
In 1.665 seconds, you decide to defend yourself, to stop that 3,500-pound deadly weapon from seriously hurting you, to stop that 3,500-pound deadly weapon from sucking you under the car and pancaking you into the pavement, to stop that 3,500-pound deadly weapon from hitting any of the innocent shoppers in that Kroger parking lot on August 24th, 2023. Now, while this is happening, while this is what you're seeing, this is what your sergeant's seeing. Your sergeant is being drugged by that same car. Your sergeant is seeing you, at least 1 foot being pushed backwards. And at this moment, Connor Grubbs has not fired. Your sergeant then sees the second foot leave the ground just before he fires. Connor does not fire until both feet are off the ground, until he is hit by the 3,500-pound deadly weapon and both feet are off the ground. Now the car keeps moving. You run to catch up to the car. Comes to a stop by way of the building. You have to get her out of the car.
Love my members.
Break the
Hey,
window
White Buff.
to get her out. Her foot is still on the gas.
Hey, Nicole.
When you pull her and retrieve her from
Welcome,
the
guys.
vehicle. You realize at that point that she needs life-saving measures. You remember, you've got chest seals in
Sorry, guys.
your car. You sprint to your cruiser to obtain these chest seals. Because the job of a police officer, even though you felt like she just tried to seriously hurt you, like she just tried to seriously hurt
Their life.
other people in the Kroger parking lot, the job of a police officer does not stop. And neither does the job of a Marine. So you go and get that chest seal. You sprint to get it. You sprint back to the suspect. And only then do you realize that not only did she put you at risk, not only did she put all of the other innocent shoppers at risk at Kroger on that day, but that she also put her unborn fetus at risk. The rest of the day, you cooperate with law enforcement. You cooperate with your work. The rest of the day, you're praying that she lives. But she doesn't.
Apparently, this is where we enter some murky waters. I'm just going to stop there. I haven't stopped at all. I've been really good. Pardon me. Sorry, my cat's on my lap. And as we've discussed before, I'm allergic to cats. So I'm trying to mute myself when I cough. With that being said, apparently Connor, the officer, cooperated and went ahead and gave a written statement. This is what the prosecution said during their opening statement, and it does not accurately reflect the video. So we'll have to see what is said in that. But that was the only thing in the prosecution that was said that I think, oh, Coco. All right, she's no longer on my lap. Apparently, I was too loud for her. That was the only thing that was said that was really with all of my research, I had never heard about that. So we'll continue.
Consider what Connor knew at the time.
Shit,
At the time that he was hit by a 3,500-pound deadly weapon.
I will not be stopping the
Connor
stream
Grubbs
anymore.
is a decorated Marine. He has never had to fire his weapon at a civilian in the line of duty before. And on this day, he faced every law enforcement officer's nightmare. Now, the prosecution, Mr. Glennon, just came up here and told you Miss Young was not an immediate threat. Their own witnesses are going to tell you differently. So pay attention when those witnesses take that witness stand and tell you that a moving vehicle at you as a police officer can absolutely be an immediate threat.
It's a human missile.
Their own witnesses will tell you differently. Mr. Glennon just tried to tell you that she wasn't a threat. But she started the car. She dropped it in gear. She hit the gas. and she hit a uniformed police officer with a 3,500-pound deadly weapon, and she drug another. She put innocent people at risk on that day. Now, we are here because Connor had the right to defend himself against a 3,500-pound deadly weapon when he was run down and hit, when he was in danger of having a broken back, a broken hip, a fractured skull, when he was in danger of being sucked under the vehicle and pancaked onto the pavement. Connor Grubbs had a right to defend himself, and that's why we are here today. Now, remember the law and the burdens and the fact that the prosecutors have the burden of proof. In every criminal case, it starts with the prosecution. And it is they that must prove to you, beyond a reasonable doubt, every single element of every crime charge, including those mental elements. If they prove their case, then and only then do you get to our burden. And it's a lesser burden than the prosecution's. It is a feather more than 50%. A slight tipping of the scales, more likely than not. That is what the standard is that we have to prove to you that Connor Grubbs was allowed to defend himself. So what two things do we have to prove? Number one, that Connor believed he was in fear, that his life or others' lives were in danger of death or serious physical harm. A broken back, a broken hip, a skull fracture. And we have to prove that by a featherweight more. The second prong that we have to prove is that his decision to use deadly force was reasonable through the eyes of a reasonable police officer, not sitting behind that driver's side wheel, but rather standing in Connor's shoes, perceiving what he then perceived. And we have to do that without the benefit of hindsight. So how will we meet our burden of a feather more than 50%? How will we meet that burden? By a preponderance of the evidence. The first prong, that Connor believed his life or others' lives were in danger of serious physical harm or death. Well, Mr. Glennon told you he did comply with BCI. He wrote a statement and he told them everything that he's gonna tell you. He's going to take the stand and tell you that he was terrified of being sucked up under that car and pancaked onto the pavement. He's going to tell you about his concerns for every other person in that parking lot. And that is how we will prove by a feather more than 50% that he believed his life was in danger of serious physical harm or death, and he believed that others' lives were in the same boat. The second prong, that his decision to use deadly force was reasonable through the eyes of a reasonable police officer. Again, not sitting behind the wheel of that car, but rather standing in Connor's shoes, perceiving what he then perceived when he was hit and run down by a 3,500-pound deadly weapon. How are we going to do that? Well, you're going to hear from an expert witness. His name is Kevin Davis. Kevin Davis has been in the field of law enforcement for longer than I've been alive. He is a former Ohio Peace Officer Training Academy instructor. He taught cadets here in the state of Ohio. He's a certified force analyst. He wrote the book on use of force investigations. He's a trained police officer from this state, an expert witness in the use of force. Now, the prosecutors are going to call some opinion witnesses also. The first opinion witness that Mr. Glennon mentioned was a man by the name of Seth Stoughton. He was a police officer 20 years ago for maybe 5.5 years in Tallahassee, Florida. He's never been certified to enforce the laws here in the state of Ohio. He's never taught at the Ohio Peace Officer Training Academy. He's never been to the Ohio Peace Officer Training Academy to sit for classes or audit those classes. So keep that in the back of your mind, because he's going to give you some opinions about a case that happens here with a police officer who used lethal force here in the state of Ohio. Keep that in the back of your mind as you judge his credibility. The second opinion witness that the prosecutors are going to call is going to ask that you doubt your senses. You doubt what you see. You doubt what you hear. You doubt your common sense. He too will give you an opinion, and that opinion will be in contradiction to the agents who investigated this case. So again, keep that in the back of your mind as you hold the state of Ohio to its burden of proof. Now, the court is going to give you some rules and guidelines in the jury instructions of how you are to analyze this. You will come to know of 3 factors, the group factors. They come from the case, Supreme Court of the United States case, Graham versus Connor. These 3 factors must be analyzed in every courtroom by every jury here in the United States of America. That is what the Supreme Court of the United States has said. Now, the other rule that you've already heard several times by this point, and the judge will instruct you, is that you are not to judge this with 20/20 hindsight. But I'd like to discuss those Graham factors with you.
I think
as you
that's
will come to
important.
learn them. Number 1 is the severity of the crime at issue. You will hear that driving into a police officer, no matter how slow, is, if it causes serious physical harm, you can still be charged with felonious assault on a police officer. You will hear that a theft plus fleeing plus some use of force could potentially be an aggravated robbery. You will hear that these 2 crimes are very severe. So we will prove to you by a feather more likely than not, that the severity of the crime, this factor, is present here. The second factor is whether or not the suspect posed an immediate threat to officers or to others of serious physical harm or death. That 3,500-pound deadly weapon hit Connor Grubbs. There will be no question that that parking lot was full of people that day. We will have proven to you at the end of the trial by a feather more that she was an immediate threat of serious physical harm or death to both Connor, Sergeant Moynihan, and everybody else in that parking lot. The third factor is whether the suspect is resisting or actively evading arrest. You will hear no less than 10 times she was told, "Get out of the car." There will be no question that this factor is also present, and we will have proven that by a feather more than 50%. All of the rules that the court is going to set out for you in these jury instructions that you must follow while you're deliberating. All of these rules will show you, the evidence will show you that on August 24th, 2023, Connor had the right to defend himself because he believed he was going to be seriously hurt. and because that belief is reasonable. Kevin Davis will tell you why Connor Grubbs took the action that every reasonable police officer would do. He will tell you why he did what he did. Connor did not set out to hurt somebody, to intentionally hurt somebody on August 24th, 2023. He went to that Kroger because he was doing his job. He was doing his job when he was assisting with a lockout. He was doing his job when he was assisting the Kroger employee in attempting to investigate a theft. He was doing his job when he was covering his partner. He was doing his job when he made sure everybody else in that Kroger parking lot was safe. He was doing his job when he was run down and hit by a 3,500-pound deadly weapon. And an immediate threat like that 3,500-pound deadly weapon, an immediate threat to the officer or to others of serious physical harm, a broken back, a broken hip, a skull fracture, or death will permit him to respond with deadly force. At the end of the trial, my law partner, Mr. Collins, will come before you and ask that you find what the evidence demands in this case. And that will be that Connor Grubbs had the right to defend himself against a 3,500-pound deadly weapon on August 24th, 2023. He will ask that you find Connor not guilty of all of the crimes charged. I thank you for your time.
Ladies and gentlemen of the jury, we're going to take our lunch break now. You'll need to be back.
What?
Not to form or express an opinion on the case until it is finally submitted to you. We'll be back about 1:15.
Perfect. Guys. Okay. Working out the kinks. Like I said, it's kinky. They got the interns running it over at NBC today. Yeah, I think they're doing Vadir on I could be mistaken, but it also could just be a scheduling issue, Anthony. I was told they were just going to do opening statements today. Like, so this is new that they were able to get in a witness this afternoon. I was also told, which I don't know if it's been announced yet, that there will be no court tomorrow or Friday. So that's good for me. I had an errand to run, and I don't know if Peter's still in here, but right before I went live, I got a phone call, and I'll have to clip this. I got a phone call right before I went live that okay, hi guys. So, I just do a whole bunch of rambling then and there. So, basically, they come back from lunch only for the judge to tell everyone that the court's adjourned for the day, which was a total waste. But with that being said, I think that after listening to those opening statements, hopefully that'll give you guys a good idea as to why I think that this case is relevant with what's going on right now, especially in Minnesota. Um, hello everyone. Uh, thank you so much for being here, by the way. And if you could do me a favor before we get off track, and if you could please make sure to like and subscribe, that would be extremely helpful. And let me go ahead and uh, get this off the screen. That's going to be it for today. I know it was a bit of a shorter day, but first of all, I wanted to see if like the internet was going to cooperate with me. And then second of all, uh, I, it was just an early day. So I appreciate you guys coming and hanging. And I do want to give a shout out to my father-in-law. Thank you for doing the Lord's work with making our bathroom functionable again. It's greatly appreciated, and watching our dogs because we are out of town. It was a good opportunity for us to let him play house and fix some things that needed fixing while also going towards warm weather. And ironically enough, in about 30 minutes, I will be able to see the lighthouse from Guantanamo Bay, which I thought was interesting. And what else? Thank you to my members. Thank you for those who liked and subscribed and tuned in today. Despite it being a short stream, I am going to make sure that we cover just the highlights on this one. The key witnesses, there was a lot of procedural stuff, a lot of witnesses that I just didn't I it was hard to keep my attention, so it's going to be hard to keep your guys' attention on it. So let's put it that way. All right. And when I see you next, it will either be in a members only stream or it will be from Jamaica. So I hope that you guys have your notification set, that little bell where you pressed subscribe. Just make sure to hit the bell and it'll ask you if you want to do personalized or all or none. You want to do all because they'll sneak by you if you just do personalized. Okay, guys. Thank you so much, Maybe, for all your help here today. Thank you to my members. Thank you, everyone. Greatly appreciate it. And I will be sharing some shorts and some instantaneous lives, especially for the members. So I hope to see you over there later, whatever. Okay, guys. Thanks so much. See you tomorrow. Bye.